Bill, I want to jump back in because before the break, you alluded to how sort of the redistricting fight in Utah is not really about redistricting.
Right.
It's about sort of a debate of what the Constitution means and what the role of the legislature is in deciding this particular issue and others, what the role of the judiciary is, and what the role of kind of the people are, either through their elected representatives or through the ballot initiative process. So I want to kind of just ask you, you kind of gave us a good recap in the first segment of just what's going on with this recent debate. What do you think about it? Like, who, of all the arguments and the things we're seeing in the news and we're hearing online, who's right and who's wrong, and why are those arguments right or wrong? Help us make sense of it.
Well, that's a great question. I really love the comment you made just as we were sort of concluding that first part of our discussion about the real question has to do with the source code. It's how are we governed, and is it the way that we should be governed? Right. This really is actually a core question. And again, I want to emphasize one of the things I think we get wrong in our discussions about these topics is we spend a lot of time talking about redistricting or about what the laws regulating abortion in Utah should be, or whether we should fund scholarships for students who are taught and outside the public school. All of these are really important policy questions. But the underlying question, I think, almost always is getting lost in this, and that is who gets to decide these issues and why. And the answer to the why question is even more important than who gets to decide. Let me kind of describe it this way and see if this is kind of maybe a helpful way of looking at it. For a number of years, for really decades, the U.S. Supreme Court was kind of roiled by a controversy over the kind of simplistic way to think of it is. Do judges have the ability to look at the United States Constitution to say, hey, the Constitution, whatever it says, it's got to deliver some results we want. It's got to get us some rights that we want. It's got to come to certain conclusions. And if the language doesn't say that, we just sort of read our preferences into the constitutional kind of, or the aura of the Constitution. And there was strong pushback over time, basically kind of really starting in the 70s, but taking off in the 1980s. From others who said, wait, we can see certainly the attraction of that to allow judges, and hopefully they're really bright and capable, to come up with good policies for the country. But there's a lot of risks with that as well. The most important risk is that they're not elected. That's not their role, under the U.S. Constitution. And if we don't have a Constitution that we can count on, if we can't look at it and say what it tells us we're supposed to do and not do, then there's a risk that we lose that the structural protection that actually undergirds all of the other protections we count on. And so over time, judges and scholars and politicians would argue over this. And I think that the U.S. Supreme Court, really all members of the court to some degree, have embraced the idea that no, it's not up to the judges to determine what the law should be. It's up to the judges to apply the text of the Constitution as it was originally understood. And so you'll see comments from justices that are, according to the news, they're on the left of issues, but they'll say, we're all textualists. We all think that the language of the Constitution is important. And the reason that I think that most people believe that, and of course, some do a better job at sort of living by that principle than others. But the reason that they believe that is that the judicial duty is not to make the law, but to ensure that the laws that were approved in the name of the people under the Constitution reflect the appropriate process for decision making that protects all of our ability to have a say, and not only that, but by keeping each part of government, the judiciary, the legislature, and the executive, in their own lanes, then there are checks that prevent overreach by any particular branch. So we ended up with, I think, a pretty good system, and I think that many of the debates we see going on in the U.S. Supreme Court actually represent a real positive development, where the judges are saying we're looking at the original public meaning of the constitutional provisions, and that's what we're going to apply. in a somewhat strange way that might not be apparent to everyone in Utah, the same kind of discussion is happening here, but it's going in the entirely opposite direction, where there was some time ago when the courts, I think, typically were focused on the original public meaning, and that language is still used occasionally in court decisions. But now the majority of the justices in the Utah Supreme Court have written opinions or joined opinions in the last little while that have said, well, but the original public meaning means something that is not confined to the text or the original understanding of those who created the text, but it's something that we can imbue with our own meaning based on our sense of what people really wanted, which of course looks a lot like the living constitutionalism side of that argument that was happening at the U.S. level, at the national level, just a few decades ago. I think that's what's going on. And so when you have a decision about the redistricting and it says, well, we think voters really wanted this, and the legislature, is not really delivering what the people wanted, even though the Utah Constitution doesn't allow for a right to abortion, we think that kind of could be implied, or we think that maybe things have changed and so that's justified now. Or of another recent decision, if the people of the state of Utah approved an amendment that says that taxpayer money can go to support children, and a judge says, but it can't go to support children if those children are not going to be in the public school system. The Constitution is essentially being amended in each of those instances, not formally, not through the process that the Utah Constitution establishes for amendments, but by and maybe it's well-meaning, but by justices kind of looking and other judges looking at the Constitution and saying, well, this is what it really ought to do. And I think that's the tectonic question that's raised by these debates.
Let me play devil's advocate for a minute, just to kind of flesh out, I think, the key point you're making. Why is that bad? In other words, why would it be bad for the court to look at constitutional or legal text and then say, well, what the people wanted when this was passed, or what the legislators meant, quote unquote, when this was passed, is actually something else? Why is that problematic?
Yeah, that's a great question, and I may say something that will sound strange. In a way, policy-wise, it might not all be there. Maybe the justices have a better idea of what our law should be. But there's three major problems with that. The first is they're just as likely to get it wrong as they are to get it right, which is true for any of us, right? The legislature is likely to get things wrong, and so that so there's no reason to think that the judges are going to guess right what people thought. I mean, in the case that involved public funding for schools, I think they absolutely got that one wrong in a really simple way. The Constitution was amended to say that public education money can be used to support children, and it just meant exactly what the words say. And I don't think there's any reason to assume that there's a hidden meaning behind that that's different than the language. So the courts could get it wrong. That's one reason. The second thing is that you can create a situation in which people feel completely powerless. I mean, we're going to pass the laws we do. We're going to elect the legislators that we want. They're going to make the law, but ultimately the court's going to be the one to decide. A number of years ago, this happened in kind of a funny way, and I remember President Bush. There was a law passed, and he said, well, I'll just leave it to the courts to decide whether it's constitutional or not, rather than saying, this is unconstitutional, I'm not going to sign it. That's a really bad system. I mean, and of course we've moved away from that, which is positive. But it creates a kind of a dependency where everyone just says, well, we don't really know what the law is. We'll have to wait for the courts to decide. And I guess the third problem associated with all of that is that, again, whatever the intention behind it is, the courts have removed from the people of the state, either through their elected representatives or through the Constitution itself. I mean, if you think about it, there are three branches of government, but there's sort of a branch even above that, and that's the people themselves. And our Utah Constitution specifically says that the people are really the source of authority in the state. And you wonder, well, what does that mean? Does that mean that they can just get, they should be able to override what the legislature does or ignore any of the procedural things? No, it means that the people are sovereign in the sense that they get to control every decision-making process through the Constitution that they adopt. and they can go and amend that Constitution if they want a different process. There's not been any interest, though, in people doing that, because I think most people recognize that there's a real value in having a system where the legislature elected by the people decides, and then there's also a built-in system for creating some accountability if the legislature makes a bad decision. And in addition to that, Utah has also decided that they're going to create another potential sort of escape valve, and that is that people, if the legislature is not considering things they think they should, they can always pass a law through initiative or repeal one through referendum. But in that case, they're just acting like a legislature would, putting forward ideas that the legislature will now just consider as a normal part of the law and be able to amend and repeal as they think is necessary. But the ultimate check is the constitutional text itself and the people's right to elect representatives and make decisions about the Constitution. And those things, if we lose those, we really don't have the same kind of system we had before.
Thanks for watching that clip of Defending Ideas. For the full conversation, click the link in the description and make sure to like and subscribe wherever you get your shows.